Today I'm going to be talking about a very subtle nuance when it comes to addressing arguments specifically before the Delhi High Court, because this is something that I've seen only before the Delhi High Court and nowhere else. Although I have seen a fair bunch of matters everywhere from the Delhi District Courts to the High Court to the Supreme Court and various other tribunals as well. Usually this is a thing that I have seen transpire mostly at the Delhi High Court, nowhere else. Now, early in the morning, when I was to argue an anticipatory bail application before the Delhi High Court, my client calls me up and tells me that the investigating officer in the case has told my client that he does not wish to arrest my client, that he has given various assurances that he will not arrest my client pending this investigation. My client tells me that he does not wish me to argue this bail application and he wants me to withdraw this bail application. I had my reservations, as I have expressed in other videos, about when an investigating officer says, I do not wish to arrest you. However, I had to honor the wishes of the client after giving him due notice of my apprehensions. Here, the client says, all right, why don't you address arguments, and if the court is not convinced, then you withdraw my anticipatory bail application. To which I explained to him that if you are very confident, then it would be much better that the moment I appear before the court, I immediately mention to the court that I wish to withdraw my anticipatory bail application and not proceed with arguments. The reason I gave was because if I address any arguments and after I address my arguments, the court says I am not inclined to grant you anticipatory bail, so you either withdraw it or I am going to dismiss it on merits. In that case, at that point of time, if I now tell the judge, my lord, I now wish to withdraw my anticipatory bail application, the order that the court will dictate and the only thing that the court will change will be that the court will add 3 extra words in the very beginning. The court will say, after some arguments. So the court will go ahead to say, after some arguments, the learned counsel for the petitioner wishes to withdraw the present application, therefore dismissed as withdrawn. And if I appear before the judge immediately and I just say, my lord, I wish to withdraw this bail application, the judge will just say, the counsel for the petitioner appears and wishes to withdraw the present bail application, therefore dismissed as withdrawn. The client could not, of course, understand the difference. I had to explain to him that this is something that I have seen happen over the past several years that I have practiced, on the criminal side of the Delhi High Court, that if I try to address my arguments and after that, if the court is not convinced and they say you either withdraw or I dismiss, and then I seek to dismiss, just as as an FYI kind of a thing for the record, when a judge says after some arguments, then the application is dismissed as withdrawn, the judge means to convey to either the police or to the trial court below or to a coordinate bench in the future that this bail application will not be treated as dismissed as withdrawn and hence having no consequences whatsoever, because these 3 words, after some arguments, have been added to this particular order. This means that the counsel for the petitioner had tried to convince this court of the merits, but because he was not able to convince, therefore he withdrew this bail application, and therefore this becomes a pseudo decision on merits. It's a little bit of a complication. Yes, in law books you will not find it anywhere. In any statute books, you will not find it anywhere. You will find no mention of this in the CRPC when you read about section 438 of the Criminal Procedure Code talking about anticipatory bail provisions. Yet, as a matter of practice and procedure, when you are a young lawyer or maybe a law student trying to understand the finer nuances of the profession, this is something that you should be mindful of. That day, I went before the judge and the first thing that I said was, I wish to withdraw my present anticipatory bail applications upon instructions of my client. Immediately, the Honorable Judge wrote, the counsel for the petitioner comes and seeks to withdraw the present anticipatory bail application. The judge did not write those 3 dreaded words. And later, my client confirmed after a couple of days that the investigating officer indeed also confirmed what I said and said that if the words after some arguments would have been there in the order, then there would have been, in a certain sense, a duty cast upon that investigating officer to go and arrest the applicant accused person. And because he has not said these three words, the judge, the investigating officer still has, ample power, authority, leeway to not arrest the applicant accused person. However, I still express my reservations. Doing this is always a risky business. You leave your fate in the hands of the investigating officer. It's a risk that my client is willing to take. But when he has chosen to take this risk, at the very least, what I could do is explain to him the difference, let him choose. Upon his instructions, I withdrew it without making any submissions. Those three dreaded words were not there, and hopefully this will be a little bit of an advantage to us.